but there's no.
No. Certainly that becomes a question. But to say I was overly concerned about that, here's what I have, counsel. I have his phone at the scene where this body is.
This is case number 24F3-0955, the people of the state of Michigan versus Fareed George Hayar. Am I pronouncing your last name correctly, sir?
Hajar, yes, sir.
Hajar, okay.
Your Honor, good afternoon. Ryan Murad, P83665.
Yes, Your Honor, Jessica Blanche on behalf of the people.
Counsel, how do you wish to proceed?
Your Honor, with regard to the arraignment, we waive formal reading. Mr. Hajar stands mute.
All right, so ordered. Now, Ms. Blanche, I'd like to hear from you on this one. I've read the bond recommendation, and I'm kind of interested in what you have to say here.
Sure, Your Honor, we're asking for a $10 million bond in this case. We're asking for a home confinement tether on release. The victim was found deceased in Northfield Township. Defendant took her body from Dearborn and dumped it in that township. Not only did he not report her death, but while family and friends were reaching out to find out what happened, he gave them misinformation. And the body wasn't discovered for about a week after he dumped it in Northfield Township. This is an ongoing homicide investigation. There's serious concerns for the community. The defendant frequently travels outside the United States. We're asking that he does not travel outside of Michigan or the United States. We're asking for him to tender over his passport. I think it's already in police custody, but we'd like to keep it while the pending of this case is in place. We're asking for all standard bond conditions, drug testing if he is released to home confinement tether. And I believe that's it, Judge. Thank you so much.
All right, thank you. Mr. Murad, what do you have to say?
Judge, a whole lot. I'd like to tell you that Mr. Hajar is a 57-year-old resident here in the state of Michigan. He's a single father of 2 children. They all reside with him, along with his 87-year-old mother that is literally under his care. When visiting his house, I met with his mother, his sister, her husband, and his children. He has a plethora of family support on this particular matter. Additionally, I'd advise that he has 26 years of employment at the same job where he's the IT director for. He has absolutely no prior criminal convictions other than an operating while intoxicated offense, no assaultive criminal convictions, no capious history whatsoever that I'm aware of. I believe he's a model citizen, Judge. He's earned his PhD from Wayne State University. He's also earned his master's degree from Lawrence Tech, and he's also the president of Professional. Again, there's no capious history. He has a whole community supporting him in these allegations. And Your Honor, when I go through MCR 6.106 Section F, I think between A and I, every single one of those factors points to a personal recognizance bond for my client. Now, I understand that these charges are serious. And I think that in order to issue a cash bond here, the court's required to determine that a non-cash means won't be sufficient. And I can tell
I know what I have to determine. Counsel, I know what I have to determine. Thank you.
Thank you, Your Honor. I would only add here.
Blanche, okay, go ahead.
I'm sorry, Your Honor. I would only add here that my client has retained counsel and will surrender his passport. We have no objection to any GPS monitoring device, but I would ask the court for a reasonable bond in this particular matter. And he's not been charged with homicide, and it's been over 70 and a half hours since his arrest.
All right. Ms. Blanche, your reason for the very high bond request was that the defendant poses a danger to the community. Can you explain that? I mean, is there some indication here that he's involved in the death? Because what the complaint says is he disposed of a dead body and perhaps chopped up a dead body.
Well, the last time the victim is seen in this case is entering his home. She never left his home. And then you see him driving to our community where the body is dumped. Has his car is seen on video. His phone location is where the dump site is. And then after that, we discover her body. So the fact that she's last seen going in his house, she never comes out of his house, then he misleads police, family. During all of this, yes, Your Honor, there's huge concern here for what happened.
All right, thank you. Mr. Murad, anything else?
No, Judge, I think we've laid it all on the record.
All right.
Just no
Okay,
objection to
thank you.
tether.
All right. Bond is set at $2 million cash or surety. The defendant, in the event that he posts bond, is to give up his passport, and he may not leave the state. And in the event that he is able to post bond at the $2 million cash or surety level, he is to be confined to his home with a home confinement tether. The probable cause conference in this matter is set for July 25th at 9 o'clock in the morning. Does that work for you, counsel?
I'll make it work regardless, Judge.
All right. Okay. Thank you. Anything further?
If I may.
All right. Thank you both.
Judge, I'm sorry, if I may.
Hang on for 1 second. Mr. Murad, did you want to add something?
Yes, please. Can you hear me?
I'm
Your Honor?
sorry. Yeah, it's like sitting in a barrel in here with the noise. So go ahead.
Sorry, Judge. I would just only ask the court to consider reduction of what it's already ordered, only because I don't see that anything has been placed on the record that my client is a flight risk, won't appear, or has had any violent history. The court rule is clear on this, Judge. I'd ask for a reduction.
That's why I asked Ms. Blanche, and she satisfied me that there is a potential danger to the community. All right.
Thank you.
Thank you.
This is a major turning point in the hearing. The prosecution pushes for an extremely high bond, arguing community danger, possible flight risk, and suspicious post-incident behavior. The defense argues the opposite: strong roots, stable life history, passport surrender, GPS tether, and full cooperation. Remember, bond is not meant to punish. It's meant to make sure the defendant returns to court and does not endanger others. When a judge sets a very high cash bond with strict conditions, it signals serious concern, but not a final judgment. Here's the engagement question. Do you think digital tracking evidence alone should justify a multi-million-dollar bond?
You may be seated. And I'm just going to give an admonishment. I'm not making any accusations or anything. There are a number of people in the courtroom. Any outburst, anything will not be tolerated. You will be removed. If you keep giving me problems, you'll be taken into custody. And there'll be no questions asked. I hope everybody is understanding.
I think everybody understands.
Court does call the case of the people versus Fareed. Is it Hajar?
Good afternoon, Your Honor. The court please Mark Krieg on behalf of Mr. Hajar.
And Ryan Murad, PA 3665, on behalf of Mr. Hajar, stand present to my right. Sir, please introduce yourself to this honorable court.
My name is Fareed Hajar.
All right.
I would give my P number, but I don't want anyone knowing how old I am.
They didn't have them then, did they, sir? No. Everybody knew each other.
My partner, he started when there was no P.
Got it. All right. This is your motion. He can have a seat.
Thank you, sir. I have filed a brief, but I have some supplemental information. Your Honor, I understand, and I did listen to the bond hearing, that there is an active homicide investigation going on. I spoke to Mr. Surma at the Wayne County Prosecutor's Office, who is overseeing that investigation. And I've spoken to Ms. Blanche, and she agrees. Here were the representations. The cause of death has not been determined. The investigation is open. There is no timetable as to when that will be completed. And it's not even clear at this stage that there is a homicide associated with the body that was found. I indicated that he is a longstanding member of the community. He has lived in this country for over 40 years, over 40 years. He served in the military and the Marines, and I have a picture, Your Honor, that verifies his service in Marines at Desert Storm. To say that he has community support is a gross understatement. Present, I'll just give a number of people who would vouch for his credibility, for his desire to appear at all of the cases to defend himself on these charges. First is Oscar Garza. Would you stand up, Mr. Garza? Mr. Garza is a retired Detroit police officer. He was a sergeant in the K-9 unit. He has known Mr. Hajar for approximately 40 years, has known him since high school. He has never known him to be violent. He has one prior misdemeanor from 2012. That's a DWI, which he received probation and successfully completed probation. I don't know if the court had an opportunity. I did give the court the URL for the Zoom hearing on the, but all that
I review all of them whenever I have a motion, so I'd seen it.
Okay, so all he said was he has, quote, the potential for violence. Outside of this offense, there's no history of violence. If he's charged with murder down the road, which certainly is an open question, so when you're charged, you're presumed to be innocent. You would assume even more so when you're not charged, and that bond can be appropriate. Judge, I'm not asking here for a personal bond, although quite frankly, under the court rules, I don't think a personal bond would be out of order. I'm asking for $100,000 10% bond with a GPS tether. He can only go to work, to medical appointments, and religious services. I think that is an absolutely reasonable bond. There's no history of flight. If the court has questions, I'd be happy to answer that.
In terms of the coordination, because this stretches over 2 counties, and you indicated that you talked to somebody from Wayne County.
Correct.
And maybe Ms. Blanche will answer this, so I was holding off in terms of the question. In terms of the murder investigation, as well as the potential charges, who would have those?
They would be our jurisdiction. So I don't know why Wayne County would say that it's their jurisdiction, because we actually sat down and had a briefing with Wayne County Prosecutor's Office, Dearborn Police, Northfield. They were present. The body is located in our jurisdiction. So if we can't prove exactly where, let's say it comes back as strangulation or something, it happened on the highway. The jurisdiction would be where the body is. So right now, correct. We have jurisdiction. If we do declare homicide, it is going to be in our jurisdiction right now. But obviously we are not there yet, but this is an ongoing active investigation.
And that just so that you know, and I sorry to interrupt you there, but that's why when you said about Wayne County, I was curious, because it would seem to me that, at least from the sketchy facts that I know, that it would be here unless there was something else.
May I, Your Honor, and
yes.
I can expand upon that a little bit. We've spoken, and I think she would agree with what I'm about to represent to the court. Wayne County is also involved in the case because they don't know where she died, and we don't know whether it's a homicide. But I spoke to Ms. Blanche, and she agrees that it's an open investigation. No charge has been brought. There's no timetable, and they have not even, at this point, determined that homicide is the cause or the manner of death. To hold this man on a $2 million cash or surety bond without even know whether it's a homicide and under what circumstances, I think is antithetical to everything that this country stands for, that someone's presumed innocent. He has not been charged. If he's charged, then whether it be in Wayne or Washtenaw County, then the court can set a bond that it believes appropriate for a murder, depending on whether the proof is evident or the presumption great. But the $2 million cash bond on offenses that theoretically the guidelines are 0 to 17 at best, and like I said, at worst 19 to 38, seems to me to be a violation of the 8th Amendment and the Michigan Constitution. If the court has questions, I'd be more than happy to answer, but I don't think I've made any representations today that Ms. Blanche would disagree with in terms of the homicide investigation.
Well, besides, I didn't want to get into the autopsy or what has been conducted so far, because it isn't relevant to the charges yet. Right. But the fact that he's making these representations in court, the medical examiners are medical examiner in our jurisdiction, and she did say that the circumstances are consistent with homicidal violence. That is, last time I talked to her, she's still waiting for the toxicology. It's pending. We won't know cause and manner until after that is done, and she wants to, hold off on drafting the autopsy protocol. But that is all we have right now in terms of whether or not this is a homicide. Obviously, it's still being investigated, but I'd like to speak just now based on the charges when I can on why I would like the bond to continue as it is.
And if, Your Honor, homicide charges are brought, I will make sure he surrenders himself.
Yeah, but counsel, if I were to have that preliminary finding, and I realize it's not a finding, but that this is consistent with homicide, then I have what was, at least from the documents filed by the parties, that there is some connection there. Why wouldn't I take that into account? I mean, what would be inappropriate, I guess, with the court taking that into account?
What I think would be inappropriate is that he hasn't been charged and he's presumed to be innocent. But let's assume that you can take it in. I think a $2 million cash or surety bond is still excessive. I mean, I'm not, like I said, I'm not asking for a personal bond. I'm not asking him.
Yeah, but counsel, what I'm getting at is you're indicating to me that there's no determination that it's a homicide.
I was not aware that there was a preliminary finding.
Right. I understand. I'm not saying that you're trying to misrepresent anything to the court. That by no means am I saying that. What I'm indicating, though, is that you want me to take into account sort of the absence of something where there's something going on and I now have something else, but you don't want me to take that into account. And I don't know that courts operate that way.
Okay. So let's take that into account. Then I think a $500,000 10% bond would be reasonable. But a $2 million cash or surety bond, it's no bond at all. And even on a homicide, bond may be denied. There's a recent Supreme Court case, bond may be denied where the proof is evident of the presumption great, but does not necessarily have to be denied. You can get a bond on a murder case where the proof is evident and the presumption great. It's permissive as to whether you remand somebody. But on the charges that he's facing now, he's entitled by the Constitution, both of Michigan and the United States, to a reasonable bond. And for a case.
So I'm hearing you, but I'm just saying the idea of what's going to be a reasonable bond is in a lot of ways also, you certainly laid out the factors in your brief, but it's also the circumstances and sort of context that I'm operating in as to what the reasonableness of that bond is. Okay. I mean, certainly that has to be taken into account. This becomes a different type of case in certain respects because there is this ongoing piece of it.
If the court does not feel my suggestion of $100,000 10% bond is reasonable, then the court can set some other bond, but $2 million cash or surety, no 10%, I just think is far excessive given that what he's facing now carries under the guidelines, in worst case scenario, 19 to 38 months.
Okay. And I'll certainly let Ms. Blanche argue, but one of the things that I'm to understand is that there is, so a couple of things. One, that there may have been misrepresentations as to the knowledge of the individual to the police by the defendant.
That's been an accusation. I have not seen any discovery yet, so I can't speak to that. I've been told that there was a false exculpatory statement made. I'm aware of it.
Correct. And also phone tracking data. So, and my point to that is this, and I don't know how much of the discovery you've seen, what you've seen or
none.
Or not. When you're telling me you haven't seen any, then I don't know what I necessarily do with that. But as I'm to gather from this, were this a circumstance of he knew the person or saw the person, saw with the person, nothing else sort of connects them there, and then the person a week later is found dead, I certainly get your point. I don't think that's what I have here, which places this, at least for me, in a different posture. Because and I'll certainly let Ms. Blanche give the argument and the information to the court on that. From what I gather here, I have, I think, his phone in the township, in Northfield Township. I have, so he's sort of tracked to where the body is.
That's my understanding.
And also,
bond hearing.
well, right, but then also that there is video where the defendant is in the presence of the decedent in this case. So it certainly, I'm not operating in the vacuum you like for me to operate in, because I think I've got something wholly different here. Now, there may be other explanations for it ultimately down the road. I'm not making that type of finding, but I can't leave that out and just ignore it either.
Okay. I get that, Your Honor. That's why I'm saying if the court doesn't feel $100,000 10% is a reasonable bond, then the court has a variety of bonds: $500,000 10% bond, $1 million 10% bond, but a $2 million cash or surety bond is no bond at all.
Your Honor, I would just argue that the factors that the court's relying on, what's been placed on the record, I still don't think is a nexus with a homicide charge. I think with count 1 and count 2, that's what the court's laying on the record here, is that if someone was allegedly found in a certain area, but there's been nothing placed on the record that tells us there's a certain dispute or certain violent tendency, certain behavior that my client is responsible for this. That has not been laid on the record. What's been laid on the record here is supporting evidence for count 1 and count 2 of this charge, not of any unrelated charge. There's been nothing before us that said that there was some sort of issue.
So let me just stop you there for a moment, because there's a bit of a problem here.
Why is that?
Because yes, that's what you're dealing with at this point. But I think that goes to then ignore the fact that there is this continuing investigation into a homicide. And then with the information, just the brief information that was presented by the people, that what they're, at least the medical examiner, is seeing is something consistent with a homicide. So, and I'll let you finish your argument, but I want to make sure that you understand how I'm seeing some of this. And that is, if on the surface of it, something is consistent with a homicide, and then I have not just the defendant in the presence of that person, but then I have tracking data that would place him in the township near the body, I'm looking at something totally different. I get what you're saying in terms of the charges, but that becomes problematic, I think, from the court in terms of the setting of the bond and release conditions, because this is something that is fluid. So go ahead.
And also, just to finish off, Judge, I don't see that anything's been placed on the record, despite everything that's been placed on the record, that a GPS tether, any sort of confinement provision with that 100,000 10% would not be sufficient to protect any community. I mean, he's hired attorneys. He's going to be confined to his home. He's going to have to put up money. I mean, we have almost this entire community here behind us. We have his 87-year-old mother who lives with him, who he's caring for. He has his 2 children. I mean, his ex-wife, I've never seen an ex-wife come and support any of my clients, Your Honor, in court. So I think we have the community.
You just don't know the good ex-wives. Go ahead.
My ex-wife came to my
I don't know.
My ex-wife came to my second wedding.
And just to finish this off, Judge,
Yes.
I'm not sure how many times the court hears this, but I've met with Mr. Hajar. I've met with his lovely family. I really, really think that this is an amazing person. I think he's going to adhere to any of your conditions. I understand that there's a serious situation going on, but as it relates to bond, I don't think that that anything's been placed that tells us he's going to violate a confinement provision or that he won't surrender his passport. He's willing to do all of this, Judge, and we have no problem with him doing this confined to his home and paying at least $10,000. But I'd ask the court to just keep that in consideration when ruling on bond.
Ms. Blanche.
Judge, obviously the victim is deceased in this case. This was called in as a missing person. Her last phone location was at the defendant's house. They went to go question the defendant. He said he doesn't know who this person was. And then they started gathering his coordinates of his phone along with video. And based on the video, the victim's last seen going into his house, she never leaves. His car at, I think it's early in the morning, you see his car lights come on, off. And then you don't see the defendant leave his home until later the day when he tracks up to Northfield Township, and her body is located in the place that his phone cords and his car. There's video, different places up in Northfield Township where he's roaming around, and her body is then discovered a week later. So she's last seen going in his home. She never leaves, and then her body is recovered a week later up in Northfield Township. I think there's huge, grave concern for the community safety. He's been dishonest with police. He acted like he didn't know her. Then he said, oh wait, yeah, I do know her. She was at my house, but she left earlier in the morning. So there is concern for community safety. And the fact that on the records in place, well, a GPS tether would be sufficient here. That GPS tether would tether him to the home that this allegedly took place at. The fact that we have a missing person that was last seen in his house. So we have a GPS tether at that house with also, he lives with his mom and his kids, who his mom, I believe, was present at that time. So you have witnesses, possible witnesses, that haven't come forward the police or even been honest in this, and we want to tether him to that house. Judge, I'm sorry, but there's a huge issue and a huge community safety based on misrepresentations by this defendant, and then also the circumstances surrounding this case. So no, I'm asking you to continue the bond, the $2 million bond. I believe it's reasonable under the circumstances. I was asked for a $10 million bond. If this was a homicide, I would ask you to deny bond. But we are asking for a bond. We're not asking you to deny bond. That's not appropriate under the court rules. The $2 million, yes, according to community safety, I believe it is. It is.
Just briefly, Your Honor, if the court thinks he shouldn't reside at his own home, maybe we can make arrangements that he could live with one of his friends, his brother, or a close friend. So there was a Detroit police officer who's known him since high school. I'm not saying, Your Honor, again, I don't want the court to misunderstand my argument. I am not saying that you shouldn't at all take the homicide investigation into consideration. What I am saying is, even if you take it into consideration, he hasn't been charged with it, and a $2 million bond is no bond at all. I mean, if you wanted to go to a bail bondsman, you'd have a $200,000 premium that would be non-refundable. They don't have that kind of money. So again, maybe he can raise some money with friends and family. He's obviously got a lot of support, but it ought to be some kind of a reasonable 10% bond. That's all what I'm asking.
But Counsel, you would agree that the reasonableness, I mean, one of the things that you're arguing to the court is that he's not a danger to the community. Correct? I mean, no, go ahead.
I don't think that's not the standard. The standard is, are there reasonable conditions that can assure the safety?
It's a huge factor, Counsel.
It is.
I mean, that's a huge factor.
It's an important factor. There's no question. But the question are there conditions that can be imposed that would mitigate that danger to the community? Nobody can say anybody is never a danger to the community unless, possession of.
Okay, but Counsel, maybe you're not following what I'm saying. What I'm saying is this. If on the one hand, and I just hypothetically place an extreme out there of, I guess the extreme would be, in my mind, what the prosecutors laid out in terms of the woman goes into the house, she never comes out. He is seen leaving. We have his phone then in Northfield Township. We have her phone at his house, so we know that they're at some point together. That's one extreme. If on the other extreme, I just have, she was at his house, but at some point she left, her phone is someplace else or goes someplace else, and then something may have intervened that happened differently. You'd want me to take that into consideration in terms of setting bond, because that would cut against him being a danger.
I don't want the court to think that I don't think that danger to the community is not a relevant factor. I hear the court completely. I've been doing this for 44 years, and I get where the court is coming from. My point isn't that danger to the community shouldn't be considered. My point is that the bond that is set is unreasonable. and you can consider in determining what the appropriate bond is. It doesn't need to be a $2 million cash or surety bond.
Maybe you
A $2 million 10%
maybe
bond.
you agree or disagree with this, but the reasonableness, especially if I were just using the one factor of danger to the community, the reasonableness of that bond that I may set is certainly going to be dependent in some way with the risk that I see.
Correct.
Right?
I agree with that.
So it really requires me to sort of analyze what's there and what risk is there. I never forgetting he's presumed to be innocent. I'm not saying that, but just in terms of the risk of what evidence is there. I'm having a difficulty here at this particular moment because I don't want to, I want a full fair hearing for anybody that comes before me. When you indicate to me that you haven't seen the discovery in some of the stuff that's coming out, and I'm not saying anybody's playing any games, I'm not saying any of that. I would just like the full-fledged argument. There may be a reason, if true, and I have no reason to doubt it, that her phone tracks to his house, which may be inconsistent with statements that he's given. There may be some reason for it. Where I'm at right now, and I understand why you brought the motion when you did, but where I'm at right now is that gets put out there. I don't have anything on the other side of that. And there may be, and it may be unfair for me to be looking from that, for that from you, if you haven't seen even the preliminary parts of the discovery.
The only thing I know is what I listened to at the arraignment and the bond hearing at the arraignment. But let's assume if let's say this was a murder, which it's not at this stage, and the cause and manner of death have not definitively been determined, I think a $2 million 10% bond would be reasonable. So what I'm saying is the court should not have to punish him and make him pay a premium of $200,000 that is not refundable. So make it a 10% bond, Your Honor.
I don't think this court gets in the business of punishing people with bonds. We just don't.
But again,
but counsel, some people, sometimes the prosecutor thinks maybe the court's being too lenient. We're letting people go because of the bonds that we've set. Then there's defense attorneys that get all upset with us saying we're trying to punish people by the bonds that were set. I can tell you every judicial officer in this court, and I know certainly for me, I'm looking at a number of different factors. I rely upon counsel to give me all of those factors. I factor in all of the things that you pointed out. Factor in, is this person going to be a danger to the community? Is there a way that I can, given the circumstances of what's going on, safely release this person into the community and the like? I go through that whole analysis.
Can I throw something out to the court that I think...
Can I stop you? Probably not.
You probably,
go ahead.
If you told me no, I would keep my mouth shut. I can tell you that. I've learned. Judge, the difference between a $2 million cash or surety bond and a $2 million 10% bond, the only difference is either way he has to put up $200,000. Either way he has to put up, but one is refundable and one is not. And even the $200,000 10% bond, the court keeps $20,000 of that for administrative costs. So all I'm saying is, Judge, if you're going to make him post $200,000, if he shows up, which is certainly isn't chump change, $200,000, that is a significant bond, and he forfeits it if he violates it in any way. And if the court feels that he should live with his brother, who would ask as a third-party custodian, so be it. But I'm asking, Your Honor, that all I'm saying is, even when you consider the homicide investigation, that a $2 million cash or surety bond is excessive. That's my argument, Your Honor. And whether...
Well, you just said two things to me, because I'm trying to figure out, and I want to make sure I'm getting your point. I understand you're saying that it's excessive. You're also making the argument, I think, that even if the net dollar amount's the same, that when all said and done, somebody, whoever would put that up, would like to get some of it back.
Well, the bail bondsman doesn't get it back.
Oh, I know. I am aware of that.
But also the difference is that he could possibly raise $200,000 with the understanding that he's going to show up. These people trust him. They would loan him the money. But with a bail bondsman, he'll never see it again. And nor will the friends and family that are willing to chip in to post the bond. He does not have $200,000. I mean, I've never, I've been doing this for 44 years, shown this kind of support at a bond hearing, ever. I mean, he's got strong ties with the community, served his country honorably, put his life on the line in Iraq.
Counsel, I'm not disputing any of that.
I know you.
That's what it is. I also realize I have people who may have led great lives, that when one's looking at it, they've led great lives, that all of a sudden something happens. Don't know what, maybe nothing happens, but all of a sudden something's in front of me that something has happened. And at that point, I have to sort of weigh in balance and try to determine what would be appropriate to have this person released.
Understood.
If I have someone who on one hand met somebody that night and then somehow or another through what nothing that really connects them ends up deceased someplace in the field or wherever, that's one thing. If I have someone who, and I'm not saying this is his case, lured somebody into a house and then all of a sudden kills them and then it takes them out and then dumps them into a field, those things on the surface can look the same, but it's a very different risk analysis in terms of what bond I set to then let somebody into the community.
I understand. Again, I'm not asking for some.
No, I know, counsel, and
But I think his 57 years should count for something, just as a homicide investigation should.
It does. His service to this country, it counts. The support, everything counts. It's a balancing for me. I appreciate the support that's come. I appreciate all the letters, everything that I've seen. All of those are things for this court to weigh. But there's something going on the other side of the scale too. I can't just take that and say, okay, well, this is it. There's something on the other side of the scale, which the people have pointed out. And the problem, counsel, and this is where I want fairness, is that those things that the people are putting forth, I don't have a I'm not hearing a counter from you. I'm not looking for you to give me your whole case. No, I'm not looking for you to do all of that. All I'm saying is what the people have laid out, quite frankly, is some pretty damning things if those allegations are there. And I'm not hearing an answer. I'm not saying that I won't have an answer, but I'm not hearing an answer. And I think the reason I'm not hearing an answer, or even some suggestion of an answer, is because the discovery hasn't been seen.
My answer wasn't going to be on the merits of the facts of the case. My answer was going to be, the court said, yes, his life does count for something. And
absolutely.
So if that counts for something, and the homicide investigation also counts for something, which clearly this court believes, and I'm not going to challenge that at this stage. So they both count for something. So they both count for something. There's somewhere in between a $2 million cash or surety bond and a personal bond. Well, because
that's funny, counsel, because what I would really be arguing in between is what their original request was, which was a $10 million and a personal. So I'm not here to just pick a number. That's not what it is for me.
I understand that.
It's not, setting bond is not a science, it's an art.
Right.
So it's tough to do.
Right. I'm not trying to beat a dead horse, Your Honor. All I'm asking is that the $2 million bond, he simply cannot make. So if the court made it 10%, there'd be if he can raise that, then he'd have to raise $200,000, which is certainly, as I said, not chump change. It's a significant bond. And I think given that he has not been charged with a homicide, but considering that that's something that is in your calculus, that's a fair and reasonable bond. That's my argument, Judge. And given his long life history that anyone would be proud of up until these charges, that is worth something. And what it's worth, in my estimation, is a reduction of the current bond.
Counsel, let me ask you. Okay. I have her phone tracked to his house.
Correct.
I have his phone tracked to the location of her body. What would you have me do with that? I'm not saying any of that can necessarily be proved, but what would you have when you're talking about me doing the calculus? What do I do with that?
You consider that down the road, perhaps there could be homicide charges of some sort, whether it be murder or manslaughter, and that be taken into consideration and is a factor. But there are also other factors that I think can assure conditions or combination of conditions, meaning tether, passport, third-party custodian, that will assure the safety of the community.
I'm wondering whether or not you would agree with that if you saw at least the preliminary discovery.
What, a $2 million bond?
Well,
I would,
with something other than what you placed in your motion. And I don't know, counsel, and I'm not trying to put you on the spot in that. I'm just saying,
if and when he's charged with a homicide, he could be remanded.
But counsel, let's say it's not even the homicide charge, but I have those factors all in the charges what I have now. That's a huge risk.
Anytime someone is released on bond, there is a risk, Judge.
Yes, but counsel, there are different cases.
That's
right. And
right.
if I have some woman who has disappeared, who ends up dead, who the phones are at the same places, and then within the course of that investigation, I have someone that you want me to let out to say, trust him that he will do this, and I look at his life, I also have that other part that he's been deceptive throughout the investigation. All of that's got to play in.
Yes, if you want to take that into consideration, I understand that. My argument, Your Honor, is that if there's going to be a $2 million bond, it ought to at least be a 10% bond. And that, I think, is a reasonable bond. I've seen homicide cases, murder cases that I've done in my 44 years, and I've done nothing but criminal defense my entire career, where I've seen in homicide cases bonds far less than a $2 million 10%, where there's significant evidence. So what I'm saying, Your Honor, is what's reasonable. And what I'm arguing is a bond that one can't make is not reasonable. I don't want to lose credibility with the court, so I get the message clear, it's come through clear, that the bond I've requested is not in the cards. But I think to have this bond where it's at and just make it a 10% bond where the same $200,000 is posted is reasonable and fair, taking into the facts in his life.
So, counsel, if I set it at $500,000, 10%.
I don't think that's $500,000, Judge.
Oh, I can do math. Yeah, I get it.
That's. Can I speak with the family for a minute, Your Honor?
See, this is the issue, because he's saying this is not a reasonable bond, but he also in the same breath says it would be reasonable if it wasn't a surety so they could get the money back. So we can bring them, we can provide the money to release him, but we want it back, so that's why it's unreasonable. So he does have access to the funds clearly to be able to actually pay the bond. So in this whole reasonable thing, there's no case law that counsel has applied with this court saying that this bond that's been set by the magistrate was unreasonable from the start. So at this point, Judge, I don't think the magistrate was acting outside its authority unless there's some law that can be provided. But based on the circumstances and the argument, I don't know how you are unreasonable at this point. Now it's just whether or not how we're going to pay for the bond.
Judge, by law is the Eighth Amendment to the United States Constitution that buy-in should not be excessive.
I will give you time to talk with the family. I'll take a recess.
Thank you.
Let you know.
All right.
To sum it up, this bond hearing shows how courts balance liberty against safety under uncertainty. The defense emphasized character, history, and community ties. The prosecution emphasized investigative signals, movement data, and potential danger. The judge weighed both and treated bond not as punishment, but as a risk management tool. As forensic results and further investigation develop, the legal posture of this case could shift significantly. That's why early hearings like this are so important. They quietly shape everything that follows. If you found this courtroom breakdown insightful, make sure to like the video, share your opinion in the comments, and subscribe for more high-stakes legal analysis and real courtroom stories.